G'day everyone and welcome to our next video in the sequence. As I just get this set up, which is Unit 3, Area of Study 1, Key Knowledge Point 2. Our quote for today is my favourite Roald Dahl quote. If you have good thoughts, they will shine out of your face like sunbeams and you will always look lovely. Only early in the year, but potentially a little bit of stress already, so a good one to just keep in the back of your mind. As I said, today we are at Key Knowledge Point 2 of Area of Study 1 of Unit 3, which are the key concepts in the Victorian criminal justice system. Why I've circled the word concepts there is that the language that we see in the study design is the language that we can expect to see reflected in an exam. So there is, and based on the skills, it's a little bit unclear perhaps, but there is the potential that when you sit an exam at the end of this year, you will see a question that is explain or define a key concept of the Victorian criminal justice system. And it won't actually ask you to define one of these four things directly. It will just say define a key concept. So in your head you need to know that language, that word concept means these four things. So you need to make sure that they're linked together. Don't, depending on what maybe a textbook says or your teacher says, don't get fooled into thinking they're like key principles, key elements. Make sure you use the term concepts because that's what the language of the exam will use. The most important skill relevant here, as I just alluded to with the question, is define and use key legal terminology. There's some really specific legal terms here, vocab terms like summary offences, indictable offences, burden of proof, standard of proof, and presumption of innocence. They're all key legal terms. So our most likely thing we're going to have to do with these is just define them. That means that our key question today, or our essential question, is what are the key concepts that exist in the criminal justice system? And that's what we'll be able to answer at the end of this. So as we just saw from the study design, there are four key concepts that are listed. The difference or distinction between summary offences and indictable offences, the burden of proof, the standard of proof, and the presumption of innocence. What we're going to do is we're just going to go through each of those one by one. So first of all, the distinction between summary offences and indictable offences. So summary offences are the designation, I suppose, that we give to what are minor or lesser offences. Okay. These are the offences that are dealt with purely in the magistrate's court. Okay, so the magistrate's court being the lowest. If you're not aware, and you need to do, we'll go over the court hierarchy later in this unit, but it is the magistrate's court at the bottom, followed by the county court, followed by the Supreme Court, and then the Court of Appeal here in the High Court at the top. So as we can see, the magistrate's court is at the bottom, and the magistrate's court only deals with minor offences that are known as summary offences. So summary offences have no jury because they're in the magistrate's court. They can be heard in your absence. So if you're charged with a summary offence and you don't show up to court, they can hear the matter anyway and determine it even though you're not there. They're generally dealt with in one day. There's not, it's not like a trial where there's 5, 6, 7 days needed. It's dealt with. You rock up to court, it's dealt with, it's done. We have basically a Victorian Act passed by Victorian Parliament called the Summary Offences Act, which lists all the things that are summary offences. And they are things, as we can see from this picture, like speeding offences that you challenge and end up in court. The most commonly dealt with charge in the magistrate's court, the most common summary offence in Victoria, is driving on Eastlink, which is a toll road in Melbourne, without being registered to drive on there. So without having an account or an e-tag, which goes in your car. And when we talk about being heard in the absence of the accused, these charges, so say I drive my car on Eastlink and I don't have an account, what will happen is they will send a letter to my house where my car is registered, and they'll say, you owe us $19 for using our toll road without paying. I might ignore that letter. What will end up happening is I'll get a letter from the magistrate's court saying that the company that owns Eastlink has basically referred this to the police, and you've been charged with driving without being registered. I can rock up to court and I'll probably get told just to pay a fine. But I might not rock up to court, and it would be dealt with in my absence anyway, and I'd probably get a notification from the court saying, hey, you didn't turn up, you need to pay this fine, and more than likely we're not going to record a conviction, so I wouldn't have a criminal record. So driving on Eastlink without an account and without paying a toll, most common summary offence. Other ones you might see are speeding offences, parking offences, those sorts of things, some really minor drug stuff. On the other hand is indictable offences. So we need to know the difference between the two. And any criminal offence, any breach of society's guidelines as listed in parliamentary law, is either going to be a summary offence or an indictable offence. And indictable offences, if summary offences are the minor ones, are the more serious offences. Okay? And these are dealt with, if I draw our triangle again, and you've got the magistrate's court here, it's out. Okay? Indictable offences are dealt with by any court above the magistrate's court. So the county court, the Supreme Court, and so on. They're heard in front of a jury. They can't be heard in your absence. You have to be there. These are the ones like the average county court trial with a jury takes 7 or 8 sitting days. So these are the ones that won't be just dealt with in one day. They'll actually be a significant length of time spent on a trial. There is the possibility, and I didn't include it, sorry. There is the possibility to have some indictable offences heard summarily. So these are known as indictable offences heard summarily. Very logical name. This is where you, even though you've been charged with an indictable offence, and these are often, or these are generally all in the Crimes Act of 1958, which you can look up online if you want. Some indictable offences that are in the Crimes Act can actually be dealt with in the magistrate's court if you request it. So basically you're offered the opportunity and you can say yes or no. For example, robbery, no matter the amount of money involved, is an indictable offence. So if you steal, $100 from someone, but you do so with violence or the threat of violence, that's an indictable offence. But the fact is that it may be only $100. You can have that dealt with by the magistrate's court anyway, and dealt with as a summary offence, even though it is an indictable offence. So you can have indictable offences heard summarily. Our second key concept is the burden of proof. There are two parties in every criminal dispute, one being the state, which we call the prosecution, and the other being the accused person, or, as in this cartoon, the defence. Whoever has to prove the case possesses the burden of proof, and this is always on the prosecution. Okay? As it says here, the prosecution bears the burden of proof. The accused doesn't even need to present any evidence at trial. If you are accused of committing a crime, you can rock up to trial and you can sit there on the other side of the courtroom and you can present no evidence to suggest that you didn't commit the crime. You don't have to take the stand. You don't have to be a witness. Now, obviously, this probably doesn't paint you in the best light to the jury, and you might want to get up on the stand and give your side of the story. But ultimately, it is up to the prosecution to prove that you did something, not for you to prove that you didn't. And that is all because the prosecution bears the burden of proof. This protects the presumption of innocence, which we talk about in a couple of slides. So that is key concept number 2. Linked to this is key concept number 3, which is the standard of proof. This is the level to which the prosecution then has to prove it. In a criminal dispute, it is beyond reasonable doubt. Now, if we had to put a number figure on this, we're talking a jury needs to be like 98% certain that you committed the crime. Okay? Why it's this high, why it's beyond reasonable doubt, is the idea that we are protecting against wrongful convictions. You should only get some form of punishment or sanction if the evidence is overwhelming, if it is absolutely certain that you did something. Okay? Imagine if it's like 60% likely that you did something, but 40% likely that you didn't. There's no real smoking gun, no piece of evidence that actually proves that you definitely did. Then it would be unfair for you to be punished. Therefore, our standard of proof is beyond reasonable doubt. As you can see from the picture, in the little cartoon, a cat killer, is that the face of a cat killer? Cat chaser maybe, but hey, who isn't? The idea of that is, and why that cartoon, I find that quite funny, hopefully you do too. I have a dog, hence why I enjoy that. He likes to chase anything really. Is the idea that if you didn't have a standard of proof beyond reasonable doubt, if it was just like, okay, is it more likely or not that you committed the crime, people would be open to things like prejudice. Like, so in this cartoon, hey, look, it's a dog. A dog undoubtedly likes to chase cats. Is it that much of a stretch that then maybe he killed a cat? Like, we don't have any evidence that he did kill a cat, but he likes to chase them, so it's probably likely that he could have killed the cat. So then all of a sudden that dog goes off to jail based on the likelihood that he could have done something, as opposed to certainty that he did. And that's what we want to avoid in our criminal justice system. No one should end up in prison or in a country that perhaps has the death sentence unless we are certain that they committed the crime. Our fourth and final key concept is the presumption of innocence. This is an essential human right. It is a human right that is listed in the United Nations Universal Declaration of Human Rights. And it's the idea that if you are accused of a crime, you should be treated as if you are not guilty until it is proven otherwise in a court of law. For example, if you're charged with a criminal offence, you shouldn't be held in a facility until your trial, so you shouldn't be held on remand unless there is a really clear rationale that that is needed to protect society. If you're dangerous and they can show that you're dangerous, otherwise you should be released out on bail, even if it's going to take 12 months for you to end up in court. You should be released to live in society, to work, to do everything you would normally do, because you haven't been found guilty yet, and it would be unfair to restrict your life based on an accusation. So the presumption of innocence is a really key concept. The burden of proof supports that. The prosecution has to prove that you did something because you are not guilty until they can prove otherwise. And the standard of proof is that it has to be beyond reasonable doubt because, again, you are not guilty until it's shown beyond reasonable doubt, beyond certainty that you are. This cartoon sums it up perfectly, where the old dog looks like he's, again a dog cartoon, looks like he's knocked the vase over, and as the judge is saying, alleged bad dog, because it's not proven yet. And we can't assume someone has done something until we have proof that they do. As I said, the most likely key skill that is going to be relevant to this dot point is define and use key legal terminology. And perhaps the sort of question that you could see on an exam is something like this. Define one key concept of the criminal justice system. This is the sort of question they like to put on an exam because it doesn't tell you exactly what you have to define or explain. You need to use a little bit of intuition to be like, okay, key concepts. What are the key concepts? They are the burden of proof, the standard of proof, the presumption of innocence, and summary offences versus indictable offences. Okay? I just need to define one of those. What will happen is you'll end up on an exam at the end of the year and say this question's on there, define one key concept. Some people will panic and be like, oh, criminal justice system concept is legal aid. That's a concept we learn about. Okay? It's not the actual concepts that are listed in the study design. Or they'll say define one key concept and they'll be like, the judge or the jury. Okay? So it's about knowing the language of the study design so we can best prepare for questions on the exam. So to find one key concept of the criminal justice system, we must explain one of these 4 things. Simple 1-mark question only needs a couple of sentences to get the marks. Okay? This answer has a beautiful little stem at the start, very, very clearly identifies a concept and explains to the reader or to the examiner what we're doing. The burden of proof refers to upon who it falls to prove a case. And then a little bit of extra detail. In Victoria, this is always on the prosecution in criminal matters. Okay? Very simple, 1 mark, not much to this. The idea being that, say if assuming the exam is 70 marks again, where you've got approximately it's about a minute 40 per mark. This is the sort of answer you can easily write out in less than a minute and allows you time later on to spend extra time on longer, more important, more complex questions. What you have the opportunity to do now is to pause the video and have a think about the 4 things, okay? The burden of proof, the standard of proof, the presumption of innocence, and summary and indictable offences, and try and use, I suppose, a bit of your higher order thinking skills and see if you can work out how they achieve and don't achieve the principles of justice. So if you want to have a little go at that yourself, pause the video now. And with that, we're going to skip to the next slide where I'll give you a few of these. So just a few of how it achieves. It is fair that allegations against you must be proved beyond reasonable doubt. That is fair because it means, or it would be unfair if it was like, oh, there's some doubt that you did it, but we're going to send you to jail. Okay? So ultimately it's fair that we have a standard of proof that is beyond reasonable doubt in criminal matters. It also, these concepts achieve equality through every accused person having the presumption of innocence. Okay? That is equality. That is the fact that every single person who is accused of a crime will have the presumption of innocence. Finally, access. With summary and indictable offences, as I said, cases are distributed based on their seriousness. This allows or means courts like the County Court and the Supreme Court are not going to get bogged down dealing with people driving on Eastlink without their car registered, because that would be a waste of, the best legal minds in Victoria, be an absolute waste of their time. So instead, we make sure that all of those minor offences are dealt with by magistrates in magistrates' courts. There's far more magistrates' courts. There's only one Supreme Court in Victoria, obviously. And it means that superior courts can focus on more complex matters. This improves timeliness throughout the court system, meaning people have greater access to the system. They don't have to go through long waiting times. So it promotes access. Basically, in terms of looking at some actual or hypothetical scenarios related to these key concepts, it would be a great idea for you to just go to any news website, find the legal section. Like I know the Herald Sun has a law and order section. I think the Age has similar. Basically find some articles on crimes and identify whether it's a summary or an indictable offence. I wouldn't be surprised if there's an exam question down the track or you get a SAT question in your class that has a scenario and then says, like, one of the first questions is identify whether this is a summary or an indictable offence. And you would need to be able to pick up those things like, okay, which court is hearing it? Is there a jury or isn't there a jury? So on and so forth. Also, just a little website that you can head to called fairtrials.org. It's an international website. And it has a section on the presumption of innocence that allows you to explore that in a bit more detail. And it even will talk a little bit, I think, from memory, about some countries around the world who perhaps do not have a presumption of innocence and what effect that can have on fairness and equality in the legal system. That is the conclusion of today. Remembering our key language here is concepts. And if you see concepts, it's referring to 1, 2, 3, 4. Can you answer our essential question to finish off? What are the key concepts that exist in the criminal justice system? Have a crack at answering that now. And when you're done and when you think you're good with that, move on to video 3. Thanks for tuning in, and remember to leave feedback through the website or through Facebook if you can.